All rise. The Lawyer of the Apes is now in session. How's it going, everybody? Welcome to episode 11 of Lawyer of the Apes. The devil is in the details. So I titled this stream that because, today I'm going to go over the motion to dismiss and the Robinhood complaint. The Robinhood complaint is premised upon negligence causes of action. But generally, this is the type of case, and I had talked about this in an earlier video, that really isn't usually a negligence case. This would usually be a breach of contract case. And the problem is that when you signed up for Robinhood, when people signed up for Robinhood, there is so much in that agreement that, a lot of times people don't read them. That's the reality, right? When we sign up for something on the internet, we just click, yes, agree to the terms of service without giving anything a second thought. But if you go back and you look, and now as you see what's in the Robinhood terms of agreement, right, you'll realize that you are giving away tons of substantive rights, right, that you may not have even thought about when you were initially signing up. You said to yourself, all right, Robinhood, free trades. Hey, sounds great. Oh, they're offering me a couple of free stocks. Oh, I'll take that. Signed up, you're a new retail investor. You thought it was easy. But again, no one was thinking about that when they first signed up with Robinhood. And it's not just Robinhood. It could be anything in life, anything you sign up for. If it seems too good to be true, it probably is. Robinhood is offering a quote unquote free service. Listen, nothing's free. Everyone's got to make money. So, the question in the back of your mind is the next time you sign up for something that's quote unquote free, what is the end game for this company? What are they getting out of this? And how is it going to screw me at the end of the day? So that's the one that we have to think about. So remember, when we went over the complaint that was filed, and remember, there's two separate complaints. There's one cause of action that's for antitrust, which we already went over, and we went over those motions, and those motions are submitted. This is the action just against Robinhood, right? Just against Robinhood and Apex, but we'll just sort of focus on the Robinhood aspect of it. This aspect of the case is not against Citadel. This is just against Robinhood. So remember, they were filing based upon negligence. They did not file anything based upon the breach of contract. And the reason for that is, we'll see when we get into the motion to dismiss, is that because the individuals that signed up for Robinhood agreed to the contract terms, they basically, signed their life away. They made a deal with the devil, right? So that's why I titled this "The Devil's in the Details." So you have to always, in the future, be careful with what you sign up for on the internet. So let's take a look at defendant's motion to dismiss the Robinhood aspects of the case. I'm going to try to go through this pretty quick. Someone said my videos are a little too long. I will try my best to make this one less than 30 minutes. Or hope even less than 20 minutes. So they start off by saying Robinhood's obligations to its retail investors are defined by contract. So again, remember, I was saying that before, that is the key to this. You or anybody who signed up for Robinhood, you agreed and entered into a contract with them. Whether or not you realize it or not, that's what happened. There was a contract. You entered into a customer agreement with Robinhood. The customer agreement expressly permitted Robinhood to implement the temporary restrictions it imposed January 28, 2021. So here's what they're saying. They're saying that the contract terms, right, that you were agreed upon when you initially signed up with Robinhood, specifically expressly stated in no uncertain terms that they had the right to do what they did. So let's cut down to what it said, right? Robinhood's customer agreement expressly provides that Robinhood can impose trading restrictions, stating inter alia, which means among other things, that Robinhood may at any time in its sole discretion and without prior notice to the customer prohibit or restrict the ability to trade securities. This authority to restrict trading was quickly reaffirmed by the Securities Exchange Commission just 2 days after Robinhood imposed the much discussed restrictions. The SEC reiterated in an investor alert and bulletin that brokers have the authority to restrict trading during periods of volatility, and that brokers may reserve this right, as Robinhood has done in their customer agreements. So here we go. They're saying, listen, this is a permissible rule under the SEC rules. We as brokers are allowed to have within our contracts a section that says that we are allowed to restrict trading. So let's just cut down to now where it says this is the agreement between Robinhood and its customers. Robinhood is not an investment advisor and did not give any of the plaintiffs here any investment recommendations concerning any securities at issue. Instead, Robinhood provides an online trading platform on which customers self-direct their finances. So here, Robinhood is saying, listen, you can't make a negligence claim against us because we are not in a relationship with our customers that would require us to have any certain level of duty to help them ensure that their trades are safe. We are just a purely contractual arrangement, and we are not an advisor. We are just a company that helps execute trades. And that's their argument. They're saying that they have no duty of care to help the people, the retail trader. When Robinhood customers sign up for a Robinhood account, they first agree to the terms of the agreement. The customer agreement addresses, among other things, the nature of the relationship with Robinhood and its rights. Customers agree that their accounts are self-directed and that Robinhood does not provide investment advice, recommend securities, solicit orders, et cetera, and so forth. So they're hammering home that the agreement is really what's at play here. And because of the agreement, retail knew, or should have known, they should have read the contract. And if they would have read the contract, they would have realized that Robinhood had the right to do what they did. That's their argument. But for the reasons that we'll discuss in a little bit, I think we're going to see that even though when you read this motion, it initially seems, they just go through the history here of what happened on January 28th. We got over that ad infinitum, but so let's just go over the legal aspect of it. Again, they're setting forth the legal standard. What is the legal standard for a motion to dismiss? As I said before, assuming all the facts that are set forth in the complaint are true, you have to look at it as in most favorable to the plaintiff, and also they just have to establish that what happened was plausible, that there is no other plausible explanation as to what happened. Now, another thing that's interesting is when you sign a contract with somebody, sometimes in the contract, it tells you what law will apply in the event of litigation. And the reason why they put that in there is because, the lawyers look around and find the law that's the most favorable, right, for these types of contract situations. So in this case, the customer agreement says that California law would apply. So their argument that California law would apply. There's no guarantee that the court's going to agree with that. Sometimes they go on other conflict of law issues, which I'm not going to get into. It's a little overly complicated and unnecessary, but their choice will either be California law or Florida law. They're saying that California law should apply, but even if it doesn't apply, their argument throughout the motion is we've also established it under Florida law. So they're saying it can be done either way. This just reiterates that they are saying that this is a California matter because it says so in the agreement. There's another argument that the plaintiffs are making in this case, which this one is the only aspect of it that I consider to be a real stretch. It's a real Hail Mary. They're saying that even individuals that were not customers of Robinhood should be able to submit a claim as part of this class action. That is a stretch. I mean, there's really no legal authority to support that. That's a tough one. Look, when you're making a complaint, you can throw in the kitchen sink. But yeah, this whole idea that because of what Robinhood did, it affected everybody. I'm not sure about that. That's a tough one. It's worth throwing it in, but again, I'm never going to bullshit you. And from a legal perspective, that is not a strong argument. I'm not saying it's impossible. It's just not strong. All right, so here we go. They're getting into now. They're saying that these allegations that they committed negligence or gross negligence are not possible because they never owed them a duty. There was no duty. So to prevail on a negligence claim, you have to establish three things. One, there's a duty to use care. There was a breach of that duty, and the breach of the duty was approximate cause of an injury. Now, this is usually a tort, right? A tort, which means torts usually mean a physical injury, medical malpractice, somebody that gets hurt in a car accident, something like that. They're extending negligence claim to a contract issue, which it happens occasionally. I had said prior that you don't see it too often, and that's true. You don't see it too often. I was never saying that it's not possible. What I was saying was that I knew that this is what they would argue because it's generally more seen in injury cases. You rarely see it here. And there is some case law though that supports it. So this argument is not that strong on their behalf in the long run, but they still have to make it, and otherwise it's malpractice. Here, plaintiffs fail to allege that Robinhood owed its customer any cognizable tort duty as opposed to a contractual duty. So again, they keep reiterating, this is not a tort, this is a contract issue. And they know they can win the contract issue. That's why the plaintiffs haven't really filed a contract issue. So they're saying this is all a contract issue, and they know for a fact, plaintiffs know for a fact that they can't win on the contract issue. So now they're just trying to throw everything against the wall and hope that the tort defenses, the tort causes of action work. So then let's get down a little further. Plaintiffs cannot invoke the independent doctrine of tort doctrine, a limited exception permitting a plaintiff to recover in tort against a contractor or counterparty where the plaintiff alleges a tort is independent of the breach. Courts have limited this exception to cases involving intentional torts, such as fraud, which plaintiffs do not attempt to allege here. So here's what they're saying is, listen, you cannot generally make an allegation of tort for a contract violation unless you can show that there was some intentional tort, such as fraud. Now, they're not specifically addressing fraud in this case, but they are alleging a conspiracy. So by extension, they might be able to argue that. It'll be interesting to see what the court does with that. Plaintiffs cannot assert a cognizable negligence claim against Robinhood based on breach of professional duty. Professional services that can give rise to professional duties are defined as those arising out of an occupation involving specialized knowledge, labor, or skill. Robinhood serves only as a platform through which its customers may place self-directed trade orders. The operative customer agreement expressly provides that Robinhood does not provide investment advice. The parties expressly agreed that Robinhood does not provide investment services that a professional would provide, and Robinhood owes no professional duty. So they're saying here, listen, you can't argue that we owed you a professional duty because we were not providing you a professional service. We were basically just being a middleman. We're allowing you to submit a trade and we'll execute it for you. There's nothing that we're doing that required us to give you any type of specialized advice or to guide you in any way. So because of that, you can't tell us that we committed some type of professional negligence. I'm going to save it for the end. Spoiler alert, you definitely want to listen to the end of this, because you're going to see that this argument is going to be problematic for Robinhood, and I'm going to show you why at the end. It's really interesting. Plaintiffs cannot recover under a negligence theory against any of the three Robinhood entities because Robinhood does not owe a duty of care. Again, they reiterate throughout this motion, and I'm not going to keep showing it to you over and over and over again. In sum, I could probably stop going through this at this point right now, because the reality is that is the entirety of their argument. The entirety of their argument is basically this. This is a contract action, right? Under contract law, you can't win, which is why they didn't really file any type of breach of contract action. And because of that, this allegation that we committed a tort is nonsense, because they're saying that if it's a tort, the tort is for somebody who's physically injured, but there are certain exceptions. And those exceptions are met in this case because, number one, we have no obligation other than executing trades. So we really have no fiduciary duty, to ensure that, you're protected. We have no requirement to provide you any type of help. Yes, we put educational tools on the website, but it's not investment advice. It is just educational tools, right? Here, even if plaintiff could allege they depended on Robinhood and placed trust in Robinhood, they have not alleged a recognition or acceptance of fiduciary obligation by Robinhood that could give rise to a fiduciary duty. Robinhood expressly disclaimed fiduciary obligations in the customer agreement, and Florida recognized that such disclaimers bar a finding of fiduciary duty. So they're basically saying, listen, even if it's true that that there might have been some requirement that we provided, we basically told you in the contract, listen, we're not providing it to you. Now, that's an interesting point that they're making, but I don't think that that's their interpretation of the contract. That is not explicitly what the contract says. As set forth above, the customer agreement provides that Robinhood may at any time in its sole discretion and without prior notice prohibit or restrict my ability to trade securities. Again, they keep harping on this. Like I said, this motion is 35 pages long, but they keep repeating the same thing over and over again. Agreement. We can stop this at any time, blah, blah, blah. That's all. That's really what they keep saying. But so at the end of the day, what does all this mean? Does this motion to dismiss, have any support? Are these strong arguments that they're making? Does the contract protect them from, this case going forward? Well, again, I'm not going to bullshit you. There's no way for me to know for sure, obviously. The courts can do various things and everything is so fact specific. So what are the two possibilities? Possibility one is the judge says, listen, this was a breach of contract action. The contract clearly says that they were allowed to suspend trading at any time. And because of that, there's no tort. They owed you no duty of care. The contract clearly says that. And therefore, the case is done. That's option one. Option two is the court says, okay, there was an agreement, but the actions by Robinhood take it outside of the contract because they did something that was so negligent and so beyond comprehension that they are at fault. They owed customers more than just the duty to say we just execute contracts. Not only do they have a duty to execute contracts, but they have to make sure that the contracts are being executed on even ground, right? When you enter into a contract with somebody, it's supposed to be on equal footing. If Robinhood, right, as a broker dealer, they have much more knowledge, right, than we do as individual retail investors. So they can't look at it from the perspective of a person who has extra knowledge. They have to say, well, Robinhood, you had extra knowledge and you should have been more forthright about not just generally saying, oh, we can hold trading at any time, but hold trading for what reasons? There has to be specific enumerated reasons. And if you were going to do it, don't do it like pull it out from under the rug. How about you give a little warning? How about you give a little bit of a heads up saying, if this continues, well, the way things are looking right now, if this continues and the volatility doesn't slow down within the next 48 hours, there may be a halt. We may have to take the buy button away. Now, I'm not saying that would have been right either, but I'm just saying, at least under that set of facts, they would have given some notice to people and it would have given them an opportunity to, make a sound decision. In this case, the buy button was just instantaneously taken away and people's orders weren't filled and orders were rejected. So based upon that, that's why I'm saying the judge will really have to dig into these facts. Robinhood is just painting this as a very clear-cut case of not a contract, no duty, goodbye, dismiss the case. Again, that for me, when I'm looking at this motion is very short. I'm not saying that means anything really, but it just seems like they were very repetitive in their motion and they just were harping on the same thing. I didn't feel like there was a lot of confidence in the wording of these papers. I felt there was a lot of, let's throw everything up against the wall and see what sticks. So anyway, so I just wanted to point out one thing and why I think that there's a good likelihood that this will survive a motion to dismiss. No guarantees, obviously, but just in my opinion and my analysis as an attorney, I would say the one thing that's very important is you have to know your judge, right? Always know your judge. So in this case, right, you have Judge Altanaga, right? So why is that important? Well, Robinhood is no stranger to Judge Altanaga. There was another case called Sterna Pinchasov versus Robinhood Financial LLC. This case was from 2020. This is the order, right? This is the decision, right, from a motion to dismiss. So ultimately, this is what we're going to get when the judge writes a decision. She writes very concise, and she writes. I mean, she's a great writer. I like her writing style. She does not, go on and on and on like me when I talk. I'm more of a concise writer than speaker. But in this case, let's go over the facts. It's important because I think when you look at this case, right, and then you look at the case that's currently pending against Robinhood, this gives you a good idea of what would be inside the judge's head, right, about how she's going to rule in this case, potentially. So in this case, the defendant, this was a similar situation, right? The defendant was Robinhood, and the plaintiff brought an action against them. Defendant's customer used defendant's broker-dealer services to provide them with stock pricing information and to place security orders, right? Defendant marketed its service to novice investors. Remember, this is an important part, right? This is not something that they talk about in their motion to dismiss, of course, but this is important in this decision. Defendant markets its services to novice investors and inexperienced traders. That's very important. Remember, when I enter into an agreement with somebody, I have to be on pretty much even footing with them. If they're going to be putting language in a contract that might be confusing or deliberately, obscure to trick people, that could have an impact. Not only that, but just in general, their marketing platform, right, is, oh, novice investors, come in, join our system. We'll help you make trades. Defendant provides customers with investing beginners guides and finance related articles. Okay, so that's the basic intro. So in this case, what happened was this involved Hertz, the ticker for Hertz. Hertz went under a T1 halt, right? So the T1 halt was placed on Hertz. The defendant did not inform its customers of the T1 halt and did not remove any type of price quotation or indication of interest for Hertz stock during the trading halt. Defendant allowed its customers, including plaintiff, to place trade orders on Hertz stock during the T1 halt. Once the trading halt was lifted, the price of Hertz stock had dropped significantly. Defendant then executed its customers' Hertz trade orders on the now devalued stock, causing its customers to lose money. Sound familiar? Very close. And in this case, they did not allege a breach of contract. They didn't allege breach of contract. Again, the reason why is because the contract terms are very, very shifty. But again, they allege two similar counts, right? In this case, that are also in the Robinhood case for January. Negligence is one. So negligence, plaintiff argues, defendant owed a duty to its customers of trading halts and a duty to prevent its customers from placing orders during a trading halt. And two, defendant breach of fiduciary duty. So is there a fiduciary duty? This is important because think about it. If in this case, the judge has already ruled that there is some type of fiduciary relationship between Robinhood and its clients, that can be that is not dispositive of the issue in another case, but it definitely can help. And it'll also be something that the judge will have to look at in terms of rendering her decision when she looks back at her prior awards. Here's a legal standard, plausibility. We already know all this. The one thing that's distinguishable in this case is that they're saying that the court would not consider the customer agreement at this stage at all. So again, there was no breach of contract. So for me, the customer agreement doesn't matter. In my argument would be the customer agreement is irrelevant. This isn't a breach of contract action. This is a tort action. The customer agreement is meaningless. And I don't think the judge even needs to get to the customer agreement. Now, in this case, she said she wasn't going to consider the agreement because it wasn't part of the complaint. Now, in the other case that's currently pending, they do make reference to the customer agreement in the complaint, which means that they could have potentially opened the door for the customer agreement to be considered. That was a iffy strategy. I'm not sure what happened there. Obviously, I know I'm not going to second guess other attorneys, but that's weird, especially if they knew about this decision. But anyway, I'm still of the opinion that it goes beyond that anyway. So here we go. So what happened in this case? Did the judge grant the motion to dismiss and said the case isn't going forward, or did they allow it to go forward? Plaintiff fails to state a claim for negligence in count one and breach of fiduciary in count two because plaintiff's allegations and duties in both counts are wholly conclusory. Under Florida law, the way that sentence sounds, it sounds like plaintiffs lose. Setting aside the customer agreement leaves defendant with only one principal argument, right? The defendant's argument is that the plaintiff fails to state a claim for negligence in count one and breach of fiduciary duty in count two because plaintiff's allegations are wholly conclusive. That's what their argument is. That's not what the result was. And in this case, they applied Florida law in this case. But again, and that's because remember, she had not looked at the contract terms, right? So the contract terms the contract terms will more likely than not apply on the aspect of the applicable law. So California law may be applicable, but Florida law and California law are very close on this issue, on these two issues. So I don't think it will have that dramatic of an impact. Under Florida law, stating a negligence claim requires alleging a defendant had a duty to conform to a certain standard of conduct for the protection of others against unreasonable risks. The existence of a duty, right? The duty, remember they said the defendant was arguing no duty. Duty is linked to foreseeability of risks at issue and may arise from several sources, including the general facts of the case. Defendant marketed its securities broker-dealer services to novice investors. These novice investor customers use defendant's interface for securing trade, including price quotations, and defendant's interface did not alert its customers that securities were subject to a T1 halt and permitted customers to place trade orders. So in this case is sort of like the opposite of the other case, right? In this case, there was a T1 halt and the trades should not have gone forward, and they allowed the trades to go forward. In our case, right, the other case, it's the opposite. They implemented a halt and they did not permit customers to place trades in order, resulting in people losing money. So it's very similar. At least my argument would be that there's an analogy here. It's analogous. The situations are similar. And if they are in fact similar and the general facts of the case are in line with one another, then since they had a duty, there was a finding in this case that there was a duty, a foreseeability, right? The foreseeability of risk. Robinhood had a foreseeability of risk in January. They should have foreseen the possibility that volatility would have had an impact on their ability to meet their requirements. And because they didn't, have a backup plan, that's problematic for them. There is a fiduciary responsibility. There potentially is, and the court found it in this case. Novice investors unknowingly placing trade orders on H1 halted stocks and suffering from price volatility. This is so similar. It's a really great case that really helps the cause against a motion to dismiss. Count 2, breach of fiduciary duty. Again, same cause of action that's in the other complaint. To establish a fiduciary relationship, a party must allege some degree of dependency on one side and some degree of undertaking on the other side to advise, counsel, and to protect the weaker party. So here again, in the motion to dismiss, in the January case, they're saying, listen, we have no relationship with these people, right? We have no relationship or requirement with the retail investor. We don't have to protect them from anything. That's what their argument is. And that's what the requirement is. You have the court say that there's a breach of the fiduciary duty if there's a duty to protect the weaker party. And the court said, defendants specifically undertaken to provide security brokerages services to novice investors. Novices are peculiarly reliant on defendants for securities trading related information by virtue of defendant's role as broker-dealer and creator of its securities trading interface and customers' own inexperience. Again, this is so important. Look at this. This court has already ruled. The same judge, the judge that's going to be hearing the motion to dismiss on this currently pending case, has already similarly ruled on this issue, where she basically believes Robinhood is in a special position. They're marketing themselves to novices, and because they're marketing themselves to novices, they have an extra duty. It's all in the wording of things. If they're just a regular trading broker and they're saying, you should have some level of knowledge or expertise, maybe this argument isn't as strong, but they are actually purposefully targeting novice investors. So that's why this case is really important. I would really advise everyone to, if you're really interested, not to be a law geek about it, but if you're really interested, I think this case is a game changer and very, very supportive of the proposition that there may be, a denial of the motion to dismiss in the short squeeze case. So guys, I don't know how long this video is, but I'm pretty sure it's shorter than most of my other ones. I hope it was helpful. I hope you enjoyed it. Until next time, the Lawyer of the Apes is adjourned.